everybody. Welcome back to Men's Day Out. Joining us today is somebody known to most of you are watching this, is Advocate J Sai Deepak. Thank you very much for joining us today.
Thank you so much for the opportunity.
So, as most of you know, Sai Deepak has represented Men Welfare Trust, which were the defendants in the Marital Rape PIL, the judgment for which has come yesterday from the Delhi High Court. Split judgment from the Delhi High Court. Sai Deepak, how do you view it? Were you expecting something like this?
So just one technical clarification. Men's Welfare Trust was not exactly a formal respondent, but its intervention was subsequently allowed. So for all practical purposes, it did become a party. Now, as far as the outcome itself is concerned, I think I don't want to sound intelligent in hindsight. Because I don't want to say mujhe pehle hi pata tha. I don't think that's how it works. Nobody knows the outcome typically for two reasons. Whatever happens during the course of court proceedings during the hearing need not always reflect in the outcome, simply because judges go back, they read, they think, right? And they apply their own experience and all of that. So frankly speaking, I wasn't sure what would happen. However, this much was clear during the course of arguments, that there was some difference of opinion in terms of the overall issue. One, on the question of whether the court should be looking into this matter or should this be sent to the legislature, and then what should be the position of constitutionality. The difference of opinion was, I think, for anybody who was watching the hearings, which was anyway virtual and live, thoda to tha, and I think it was a very healthy difference of opinion.
So, Sai Deepak, there's a lot of misinformation in the media, particularly if you look at social media, because anybody who is, trying to put out an alternate opinion or even to have a logical debate, you are being labeled as a rape apologist, or if you're a man, you have been, labeled as a potential wife rapist. Now, for once and for all, can you put an end to this debate and, clarify that what exactly are we opposing? And, are we trying to advocate rape of a wife, or what is it exactly that we are talking about?
See, on the larger picture of the civility of the discourse and the openness to a different point of view, I think this is now to be expected, particularly when it comes to gender-related issues, because the very act of speaking up and coming out with a slightly different opinion and still largely agreeing on the principle was enough to stir a lot of hostile reactions during the course of arguments, to the extent that so-called well-known legal platforms misrepresented my position during the course of hearings, which resulted in a lot of abuse and trolling online. And subsequently, even after the judgment was pronounced yesterday, when they were recounting my position as to what I exactly submitted, they continued to misrepresent it. So when they reached out for opinions, I basically said, look, I don't trust your platform. Why don't you send me something in writing and I'll respond to you in writing, because whatever I say orally will be misrepresented again. Now, let's be very clear in terms of what the position is. There are two aspects. One is the issue of forum. The second is the question of the resolution of the issue itself. As far as the forum is concerned, the position that's been taken is very, very straightforward. That when there is an exception to a specific offense, and the exception is challenged, and if that exception is struck down, then the scope of the offense is enlarged, which means that unlike Section 66A of the Information Technology Act, or the case of Section 377 of the IPC, which was read down, in this case, the prayer sought by the petitioners would have resulted in enlarging the scope of the offense, as well as bringing in more people who would be punished under that particular provision. Therefore, the position that we had taken was that a court cannot do this, because this is not a plain and simple question of constitutionality. Any finding of unconstitutionality would mean that the proviso to exception, the exception to Section 375 would be struck down, and therefore people who were previously immune to prosecution under Section 375 would now be prosecuted under Section 375, and therefore the court has to be cognizant of this direct consequence. So therefore, according to me, this issue was best decided by the legislature, not by the court. Second, even in courts, High Court and the Supreme Court exercise different powers. The power of a High Court under Article 226 cannot be compared with the power of the Supreme Court under Article 141. With respect to, let's say, filling in a legal lacuna, so to speak, or let's say filling in a legal gap, so to speak, the High Court has very limited powers. And in this case, this was not even a case of a lacuna. There is a law to the contrary, and therefore directions cannot be issued to the contrary unless and until that provision is struck down. Therefore, all we had said was let the legislature decide. 2, we never said that the question of sexual violence within spouses should not be recognized. This was never the position. The position has always been recognize spousal sexual violence. However, every other jurisdiction has avoided using the term rape in the context of something that happens within a family for one reason, that even if, let's say, the accused deserves to be punished, others should not bear the brunt of it, especially because this happens to be within the family. Therefore, as opposed to rape, kindly avoid using rape and go for spousal sexual violence. Therefore, this was the question of labeling, but not saying that let's not recognize this, and therefore let us throw the question of women's dignity under the bus to protect marriage as an institution. That argument was never made. The second argument that was made was the impression given in court and outside court was there is no remedy whatsoever to someone who is the victim of violence and non-consensual sex or sexual intercourse without consent within a marriage. To that, specific provisions were pointed out that if it comes to a point where the husband has zero respect for the wife's dignity whatsoever and does not understand a no is a no, effectively the marriage has broken, right? So therefore, for all practical purposes, the wife's first option under 376B is to show that although we live under the same roof, we are no more behaving as husband and wife. I'm effectively the victim and he's the abuser. Consequently, it is possible for a judge to arrive at a conviction under section 376B, even if there is no formal separation between the husband and wife, even if there's no divorce. So therefore, I pointed out that section 376B specifically says legal separation or otherwise, which is to say you could cohabit, you could be sleeping on the same bed, and still you may not be living as husband and wife. That requires a certain degree of preliminary inquiry just to understand what is the health of the marriage and the strength of the marriage. In addition to 376B, since this is an adult conversation, pardon me for using certain language, 377 speaks of unnatural sex. Now, when you speak of unnatural sex, one of the first things that comes to mind is you're looking at anal sex as opposed to normal conventional sex. Now, there is no exception under 377, which is to say, if the husband commits the act of what is known as buggery with the wife, then there is no marital exception. There is no immunity, right? And in most cases, 377 is invoked as on date, okay? Plus, you take a look at 498A. Cruelty includes sexual cruelty. That's been decided multiple times. Then under Domestic Violence Act under Section 3, abuse, it specifically speaks of even sexual violence. Violence includes sexual violence, and they don't say sexual violence not amounting to, let's say, intercourse. Never. The outer limit is not even defined. So for all practical purposes, these remedies exist. Now the answer from the other side was, but Domestic Violence Act only gives you civil remedies, there are no criminal remedies. This was such an unfortunate misrepresentation. Specifically, we had to show under section 19(2) of the Domestic Violence Act, the magistrate takes a look at the domestic incident report, what is known as the DIR, and then he prescribes a series of measures to protect the victim, which also includes any direction to protect the safety of the victim in any manner. And under that particular section, there are instances where registration of FIR under 376B, 377, 498 has happened. So the argument that there is no remedy, this person has absolutely no recourse to law under the existing framework as it exists, I'm sorry to say is unfortunately inaccurate and completely, it's got no basis in facts. But the most important thing is their argument was the remedy may exist, but it is not enough. If the remedy is not enough, that is not proof of unconstitutionality, that is not a ground for unconstitutionality. That is for the legislature to consider. समझ लेते हैं कि आज के basis में we come to the conclusion that the punishment for rape also is insufficient in terms of sentencing. And that is a ground of inadequacy. Are you telling me that a court can increase the punishment and sentence over and above what is prescribed in the statute? That can't happen under any circumstances. So what is the alternative? Let's assume for a moment that there is a legitimate grievance that this is not a sufficient deterrent. So what is the alternative? Alternative is this. So we said, petition ko pending rakhiye before the court. Direct the legislature to show progress. To say, आप कह रहे हैं कि आपको stakeholder discussion करना है. How long do you need? Proceed and finish it. And give us a final decision. Which way are you going? So a court can entertain a petition to push the legislature into acting on that particular subject. It still can't decide what is the outcome the legislature must come out with, right? So of all the petitions that were filed in this particular matter, only one petition had one specific prayer, which was asking for oversight of the court on the legislative process so that it is pushed and expedited. We said this is the only prayer that can be granted, no other prayer can be granted. So to clarify, no, marriage as an institution is not being cited to effectively say women have no rights or that conjugal rights must prevail over the right to say no. Nothing of that sort has been said. However, we have only said that there is a conscious distinction that the legislature has always struck between let's say sex between random strangers or rank strangers and people who have known each other for some time. Think about it this way. We are at a stage where even live-in relationships are being treated at par with marriage, right? So it is not as if domestic violence is limited only to marriage. In fact, it specifically says it goes beyond marriage, but also to marriage-like relationships or spousal relationships. Similarly, 376B applies to such situations. 377 also applies to such situations. Therefore, we said, if there is a certain degree of familiarity between two parties to the act of intercourse, then the standards and evidentiary standards will be slightly different. Let's take a very, let's say, a real example. Assume that a rape accused and the victim, or the, let's say, the person who's the accuser, have never known each other at all. Then the accused has to explain what was he doing with this lady when they have never known each other. Then the circumstances become very, very relevant. But if they have known each other, they've been in some kind of, let's say, a conjugal relationship, whether within or outside marriage. At what point do you know that the no button has been pressed? I am not saying, therefore, let's not recognize this at all. We are only saying, in a country which also recognizes the concept of an oral contract, but the evidentiary standards will be different. Similarly, when in these matters, you have slightly different standards. Now, the best part is, the petitioners were citing international jurisprudence to say all of these countries have recognized violence within marriage, sexual violence within marriage. The very same countries also recognize different standards. The very same countries don't call it rape. The very same countries also recognize that the person who's accused has the right to say, but I presumed consent for so-and-so reasons. This was the conduct, or this was the speech, this was the statement. In India, in this proceeding, until we pointed out that Section 114 of the Evidence Act effectively says that there is a presumption when it comes to certain situations that as long as sex has taken place, the victim's word alone is sufficient to demonstrate rape and establish rape. So we had to say, assume that you were to apply this provision to a marital relationship or a marriage-like relationship, there ends the matter. And there are instances where 498 has been abused. Now there will be an added instance where the very same allegation will now translate to a very specific allegation of rape within a marriage. Now, to that, yesterday, or rather last evening in a debate, a well-known, let's say, someone who I respect and who practices in the Supreme Court, who comes from the other end of the spectrum on the subject, she basically said, no, but these observations by high courts and Supreme Courts on the abuse of 498 are offhand observations. They were never offhand observations. They were observations passed in the context of specific instances that the court was confronted with. So the interesting part is, when instances of abuse are highlighted, they're dismissed as offhand. And the legitimate concern that this could be potentially misused, and therefore why don't we have a situation where the legitimate expectations of the wife and the legitimate expectations of the husband to protect himself, both of them are balanced in some way. Now, you have to realize that today, There are petitions pending before the Supreme Court asking the court to recognize same-sex relationships also under marriage acts. Okay. Now, how do you define husband and wife in those circumstances? Role कैसे define करेंगे? Because gender तो एक ही है. Now, roles are different from gender association. Yeah, I completely understand that. Now, how are you going to decide this? Now, who is going to say that this person is the wife in the relationship and that person is the husband in the relationship? Now, when these questions are raised, we specifically said the irony of the entire litigation is people fighting for women's rights are asking for gender-specific rights, and the men were asking for gender neutrality. Fortunately, Justice Shakdar has agreed with this.
Yeah.
Right?
Which is also not highlighted very much in the media yesterday.
Exactly. The fact that the petitioners did not point this out, and it was the men's rights organizations which pointed out two things: the problems with the application of presumption. Fortunately, Justice Shakdar says, I agree that this presumption can be used in a detrimental fashion, and that gender neutrality is important. Imagine the selective manner in which international conventions are being cited. Equality के लिए cite करेंगे, but gender neutrality when it comes to rape के लिए आप cite नहीं करेंगे. So
I mean, all other countries even have a basic gender neutral domestic violence law. In
Correct.
India, men don't even have recourse to that. I mean, the only recourse you have as a man is to file for divorce, which is a civil action you can take. So, when you compare, you're so selective in comparing the other jurisdictions, which is, which is common people really don't understand.
Correct. See, just one thing we have to realize, I am not going to make the statement ever that every woman who is going to exercise this law is a potential abuser of the law. I think that's a horrible statement to make. ये कभी नहीं कहा है. ना argument के time पे कहा था हमने, ना social media में कहीं पे कहा है, nor in the written submissions. But the position of the other side seems to be that every husband is a potential rapist and wife beater. There is no sense of proportion. There is no sense of middle ground at all. You're talking of a family institution. This is not commercial litigation where you can invest your personal egos in this battle. You have to try and find out what are the non-adversarial solutions you can come out with without ever letting someone get away with an act of forced sex. I repeat, there can be no justification for protecting an institution where there is only one party to that institution who's constantly the victim and the sufferer. Sorry, that is not acceptable. But that applies both ways. It's a two-way street.
I think that, for them, justice is only when justice or laws are made in favor of women. They don't understand that, in a country which is having a population of 1.4 billion and where 50% is male, you can't have laws which are completely lopsided in, favor of just one gender. And you are seeing the result of that. You ask so many families today who have sons, and, all of them are either facing multiple cases in matrimonial matters or, there are the threat of, getting a police call because the wife would just go and, file a mere complaint. So somewhere we need to relook at these laws, and despite that, we are wanting to push yet another law which is, going to completely, I don't know how to even put it, because if there is a marital rape case, and as you rightly said, all cases are not going to be false, but how would the man defend, his position? That is the main question which, a lot of men are asking in social media, whether they have anything to do with it or not. They're saying, how would we defend? What would be our stance? Because if the woman has said that, okay, I didn't consent, and the judge is going to take her word for that, what will be the man's defense?
See, if I just said everything that you said, जितनी गालियां पड़ रही हैं social media पे उससे ज़्यादा ही पड़ेंगी. So all I'll say is this. So let's look at it this way. At a time when there is a youth demographic which is significant in this country at this point. There is a huge demographic dividend that we are currently enjoying. And obviously, when this happens, the society goes through a phase of sexual liberation. That happens based on the average age of society. Now, therefore, there is a lot of sexual exploration going on and even pushing of the boundaries that's happening. Okay, whether it is outside of marriage or inside of marriage, in both places this is happening. Now, when this happens, how are you going to dictate the terms of courtship or mating? Or let's say, what are the initial steps to be taken? Please realize, I am not saying that given the complexity of the matter, it is best left unlegislated. No. However, when we say that there are safeguards required, the immediate argument that comes from the other side is, okay, please name a law which is perfect and which has never been abused. Is that the argument that you effectively want to present when we are saying safeguards hone chahiye, and you're therefore saying every law is capable of abuse, and therefore why should we have safeguards here? That's not the argument. Please understand that even the most watertight law is capable of being abused. However, the job of the legislature as well as the judiciary is to constantly perfect it and tighten it so that the scope for abuse becomes less. Today, when you're discussing the possibility of a better recognition for spousal sexual violence and you have a relatively clean slate, so to speak, we are saying let us start from a better position as opposed to starting from a position where the potential for abuse is rife. Now, during the course of this litigation, the petitioners have made at least two important concessions, rather, three important concessions. One, the presumption under 114A is problematic, right, as far as marriage is concerned. Two, gender neutrality ki zarurat hai. Evidentiary standards must be different. If Justice Shagdhar, during the course of this litigation, has effectively agreed that there are legitimate meeting grounds here, have we not established that there is some sense to be made from this side also? Assume for a moment, if none of us had ever appeared and हमारी तरफ से कोई representation ही नहीं होता, then would these points have come forth? No, not at all. Because the petitioner has taken such an extreme position. Please remember, there are some cases in, let's say, on the petitioner's side where there are real victims also. I can't judge whether they are real victims or not because the matter is still pending. I am willing to take on face value that all of this exists. I am not trying to be insensitive to them. But I'm only saying, kindly don't your case alone as an example for everybody else. Because in a society, you're bound to have counter examples also on the opposite end of the spectrum, which is exactly why the legislature is ideally supposed to commission a study from the Law Commission asking for representation from stakeholders. एक basic baseline study तो हो जाए कि आज के डेट में सेक्सुअल हैरेसमेंट लॉस का अब्यूज, प्रॉपर यूज कितना हो रहा है और कौन कर रहा है. If the Supreme Court's verdict on such issues is treated as offhand comment, high courts are making offhand comments on abuse of Section 498A, then who are you willing to trust? And is it the case of the petitioners that other than the petitioners, nobody has the right to even speak on the subject? Here's the worst part. I was even told on social media by some junior practitioners in the profession, sir, how can you oppose this petition? Unfortunate, it is so unfortunate in a country where terrorists can get midnight representation and the Supreme Court can open for convicted terrorists also. All of this can happen. I am not entitled to make one submission to say that there has to be a middle path. Ajeeb situation.
No, but look at the irony. Yesterday we had two major judgments, or not judgments, rather, two events which happened from the court. And who better than you, would want to throw light on that? So when it came to the Supreme Court, order on the sedition part, they said, oh, it's a very draconian law and, you have to scrap it because of its misuse. But the same thing when you talk about 498A, they said, oh, which law is not misused? You can't scrap laws. Even murder law is misused. So, that is the kind of arguments and which is such a big hypocrisy around it.
Frankly speaking, I think it's a position of convenience. Where you think that there is abuse and you're the affected party, you basically say, let's scrap the law altogether. Even safeguards are not enough. When the very same argument is applied to a different context, then you become a misogynist and whatnot. I see, that's the interesting part. I've tried during the course of arguments and even in the rest of the places. These ad hominem attacks तो चलते रहेंगे, उससे कोई फर्क नहीं पड़ने वाला है. The good part is, fence sitters who were truly interested in understanding the issue, the one thing that I did with the permission of the clients was to put out my written submissions in public domain.
Yeah.
Which is to say, what I said and what I did not say is capable of being misrepresented and twisted and taken out of context. Here I'm committing myself to something in writing, now read it. And this position which was taken in my written submission is not different from the original intervention filed by MWT. They've always said this. In fact, I was astounded at the amount of research that MWT had undertaken, even before lawyers had entered into the picture, where they had collated the legal position across the world, beautifully presented. So legal position with respect to what exists in Nepal, in United Kingdom, in United States, in about 18 states and all of that, my written submissions reflected the research of NWT on that particular subject. The contribution of the legal team that we put together was with respect to technical objections on jurisdiction, on interpretation of CRPC, IPC and all of that. But on international research, MWT had done scintillating research. Now the funny part is, you're aware of this. So when I entered the matter, I originally entered for other proposed interveners.
Yeah.
And we were told that the matter had reached such a stage where the court was disallowing interventions on both sides. Now, surprisingly, amicus in this matter were appointed only this year. And
Almost
interestingly,
at the end of arguments.
and almost at the end of arguments, or let's say even if it's in January, the fact of the matter is, I've said this in my written submissions, that when both the amici have the same position, you must balance it at least by having people from the opposite side. So I'll give you a very clear example. In the Sabarimala matter, the Supreme Court, realizing that there are opposing points of view and there is a significant amount of battle to be fought there, appointed people for both sides, both of them representing their legal positions commonly for both sides. In this case, I've said this in the written submissions that perhaps this should have been undertaken so that there is balance in representation. Now, here's an instance where the petitioners are speaking against the existing framework. The amici are also speaking against the existing framework. At the end of the day, the government has not taken a position yet because stakeholdership consultation is going on. It was left to Mr. Kapoor and me to argue. I felt it was slightly lopsided, but nevertheless, fortunately, I think Mr. Kapoor did a brilliant job even before I entered the matter. And after I entered the matter, I did whatever I could. So I think in matters such as this, the one thing that has come out very, very clearly is that a court of law is not the best forum for policy making. You need representation from subject matter experts. The people who I wanted to enter appearance for were scholars and researchers of gender studies who've been doing this for decades and who've been consulted by the government of India multiple times, regardless of who is in power. Unfortunately, that intervention was not allowed. But fortunately, MWT did not have a lawyer to represent them. And I did not have a specific party when I appeared for interveners. I think MWT effectively ended up seeing me. So, which is why the next day, during my opening submissions, I had to say that demand has met supply thanks to the court. So, I think this also exposes to a significant extent the inadequacy of the judicial forum for the purposes of law and policy making. I'll give you a simple example. Copyright amendment bill जो है 2011, 12 और 13 उस टाइम पे आ रहा था, where the point was how do we protect the authors, people who don't have a voice, especially the small authors against the big industry stakeholders. When people sit on a negotiating table, just because they're sitting on a table doesn't mean that the power balance is the same on both sides, right? So that उस inequity को कैसे कम किया जाए was the question. The consultation with industry stakeholders went for at least 2 years. For copyrights, are you telling me that for criminal law, where you're looking at overhauling the entire system, not just with respect to rape laws, but across the board, you don't need at least 2.5 to 3 years? Fine. Now, according to the court, the legislature has been lagging behind. I understand. ये तो होता ही है. I don't disagree. That is exactly the time you need the court to crack the whip and say, speeden up the process. But the petitions themselves are pending before the court for 7 years. 2015 में file हुए थे. 2022 suddenly it's taken up in a matter of 2 months. It's over. In such a serious case. Now, when somebody chooses to say that the other organ has not done its job, well, I would say then perhaps we should also consider the fact that the court has also kept this pending for 7 years. And therefore, if the delay on the part of the legislature warrants some kind of a judicial intervention, should judicial delay translate to legislative intervention? That was a question I put to the court, basically saying, इतने सारे cases तो court के सामने pending होते हैं. So would you allow the legislature to suddenly pick up one of the cases and say, इसको इस तरफ decide कीजिए, not just to say इसको quickly decide कीजिए. The legislature should also go on to say it has to be decided on these lines in this manner. Would that be permissible? Independence of institutions under the constitution applies to everyone. It is not the sole repository of one particular body. So the funny part is I think there have been acidic reactions to Justice Harishankar's well-reasoned opinion. You may disagree with the opinion, but I don't know what to say.
No, I was going to come to that because this is not a recent trend. If you recall, just before CJI Bobde was going to retire, there was one a rape on pretext of marriage law. That case had gone to him, and it was a case where the girlfriend had accused her boyfriend of not marrying her. So CJI Bobde made a statement. He asked the boy, "Would you marry her?" Now that was the case. The girl was saying he's not marrying me. That is why I'm charging him of rape. and it was blown out of proportion completely. They put out clickbait headlines saying CGI is asking the rape accused to marry the victim.
Right.
So
Right.
similarly, whenever we see any judgments or any orders which are coming, which are not supposedly in favor of women or not as per the narrative of feminists, you see a lot of media bullying, a lot of name calling happening in social media. In fact, yesterday, one of the feminists, I don't want to name her, I'll put out her screenshot later on, she's actually called Justice C Harishankar an ass.
I
I
was
mean,
just about.
is this allowed? I mean, as a lawyer, I think you need to, I don't know. I mean, is this allowed? If a man would say this, for the other side, would he be, given a free pass like this? So what
So
I'm
here's
trying to say is that they are creating so much of pressure in the media against that judge who is, giving a balanced judgment, that perhaps there could be some kind of influence in the, in the future on that person.
See, I hope that these comments are not being put out in the hope of influencing anybody. As someone who practices in court, I understand that a certain degree of pressure is put through headlines, because the day of the judgment, one publication, the print comes out with an article with statistics on how many women are being raped within marriage and all of that. Now, I'm not going to question the statistics because I'm not in a position to, but the timing was seriously suspect. But theek hai, koi baat nahi. A former judge of the Delhi High Court, who is now the Chief Justice of another court, his conduct with respect to the Bhima Koregaon case was called into question. With respect to, not Bhima Koregaon case, I think this was with respect to one of these activists, Mr. Gautam Navlakha or someone. And when that was done, the people who put out those tweets were immediately hauled up for contempt by the Delhi High Court. Okay. Now, here is an instance where a so-called senior journalist or a commentator uses such a derogatory term for a sitting judge of the Delhi High Court merely because she disagrees with his opinion. One, I'm not going to say, would a man be allowed to say the same thing? I'm simply going to ask, regardless of whoever says it, it's wrong. However, look at the confidence with which you think you can get away with it.
Yeah, that is the point.
The impunity with which you say these things reflects a fundamental lack of civility, according to me, and a certain degree of hubris and arrogance that this position is incapable of being challenged, and anybody who does that will have to face the wrath of the so-called ecosystem, then be called all sorts of names. Well, I'm sorry, I don't really give a damn about these things. As far as I'm concerned, if there is a position to be ventilated, I will certainly ventilate the particular position. But I genuinely believe that it reflects a certain degree of childish arrogance, which is to say, if it's not my way, then it's the highway. Okay? And interestingly, the judge who has agreed with the petitioners significantly also finds some merit on the other side. That's exactly what I'm saying, that the entire position has been reduced to black and white. And I don't believe in labeling all feminists with the same brush, because I've seen enough diversity in opinions. I have some close friends who are feminists but who also understand concerns from the other side. They're fighting more for equity, as opposed to saying that everything that relates to a woman and that relates to a particular gender must necessarily yield a certain outcome. Trained lawyers and people who are feminists as well as trained lawyers understand where these positions are coming from. The interesting part is those who know the propensity for abuse when it comes to 498A and other similar provisions in the context of divorce matters and family courts understand where these concerns are coming from. But the ones who are simply twiddling their thumbs and just shooting out opinions from their hip on social media, I think they are the ones who need a bit of education. That's why once the judgment was delivered last evening, I basically said, please read both the opinions. Look for meeting grounds, look for solutions, and don't invest your egos into this, because this is not about personal ego battles. This is about institutions and individuals.
So I was asking you after this session, I hope you're not a victim of the cancel culture yet again, something that you face at the Stephens College during the course of this, arguments.
No, so I don't think the entire college is to be blamed, because it was students of the college who invited it, and it was officially endorsed even by the authorities of the institution. A certain group had a certain problem, and which is okay, because at the end of the day, we are suffering the consequence of the woke culture across the board. So maybe this entire fracas is a manifestation of the cancer which I called as wokeism. But at the end of the day, I think youthful rebellion sometimes must just be treated as that. उससे ज़्यादा और क्या बोलेंगे? The fact of the matter is, 2 weeks ago, St. Stephen's, I mean, a group within St. Stephen's has a problem with my positions on certain issues, on hijab and other things. The Divinity School and the South Asia Institute of Harvard had a conversation with me barely 2 weeks ago, I think on 21st of April, with Diana Eck, Professor Diana Eck, effectively moderating that particular session. And the session was also chaired, or rather, it was we had participation from Professor Faizan Mustafa from Nalsar and other places. So that's what I'm saying, that when they enter the world of adults, they will realize that the world is not exactly divided in black and white. But since they are still in college, I think that youthful idealism, where you try and look at the world in binaries, is still allowed. I think that accommodation is okay. So I don't take it seriously. I'm certainly not craving for recognition from any particular institution. It doesn't make a difference. In the age of internet and the social media, a voice cannot be stopped. And I don't think my voice can ever be stifled and silenced. That can't happen. I will say what I have to with support and with civility. And if the other side resorts to uncivility, then it's a proof of the fact that they don't have arguments on merits.
Well said. And before I let you go, Sai Deepak, everybody wants to know that was your representation is it only going to be limited to this PIL, or would you also stand up for gender neutral laws overall? Because if you see the current matrimonial laws, they're completely favoring women, and a lot of men today are suffering the brunt of these laws which have been made decades ago. Would you take this fight ahead for a gender neutral society?
So, first of all, as a commercial and constitutional arguing counsel, these matters I take up on a pro bono basis depending on my bandwidth. And I certainly don't see myself in the activist mold. I got into this matter primarily because I felt that this would open the floodgates for judicial intervention of a very different nature altogether, coupled with the fact that I perhaps felt that there was not enough representation from this end of the spectrum to basically present this point of view. So, to be honest, as far as your question is concerned, if I believe that there are certain causes which I can invest in depending on my professional schedule and where my bandwidth is necessary, I'm happy to do so. But I genuinely don't see myself in the campaigner mode. I'm not fighting for, let's say, gender-related issues, so to speak. I don't want to paint any such picture of me. I will certainly participate in these matters primarily from the standpoint of balance and, let's say, fair representation of opinions. So, to answer your question, my participation will be limited to that of a lawyer and not as an activist. I hope that answers the question. Thank you so much, Amnasji. Thank you for this opportunity. I hope I've answered your questions, and I hope your viewers find the answers at least fairly informative, even if they don't agree with it. Thank you so very much.